Good afternoon, everybody. I'm delighted to welcome you to today's webinar on the legal aspects of exporting, the second in our three-part series on managing the different risks involved in international trade. My name is William Barnes-Graham, and I am the Digital Content Manager at Open to Export. We are an online community helping small UK businesses get ready to sell overseas through our step-by-step articles and guides, regular webinars, our Export Action Plan tool, and our quarterly competitions. You can find out about all of these on our website at www.opentoexport.com. Open to Export is powered by the Institute of Export and International Trade, the UK's only professional membership body for traders, offering a unique range of individual and business membership benefits, education and training catering for beginners through to master's degrees, and an always exciting and prestigious programme of events celebrating UK businesses' exporting achievements. We will be running a live Q&A at the end of the session, and you can ask questions during the webinar using the question box on the control panel to the right-hand side of your screen. This Q&A will be cut short a little bit today for reasons which I'll go into in a second. Next slide, please. So yes, we've had a last-minute change on our speaker today. Kirsten Toft, the Vice Principal of Virtuoso Legal, is stepping in for Liz Ward, who was advertised to be speaking and who's had to take on a case today. Kirsten will also be assisted by Martin Hendry, and yeah, we will be cutting the session slightly short to account for Kirsten and Virtuoso's schedule at the moment, and we will try to get a few relevant questions during the Q&A section anyhow. For those of you who haven't come across them, Virtuoso Legal are a boutique firm of intellectual property solicitors. Over the past 10 years, they successfully represented clients in hundreds of IP matters and are some of the finest lawyers out there when it comes to international trade generally. So without further ado, over to you, Kirsten.
Thank you very much, Will. Yeah, I've stepped in today to do this talk as my colleague Elizabeth Ward was unavoidably had to attend something else. So forgive me, I am fairly new to this particular presentation, but I shall do my best. And I also have Martin with me to help along the way with certain aspects of the talk. So yeah, I'm an IP intellectual property solicitor with over 18 years worth of experience. I'm the Vice Principal of Virtuoso Legal. Virtuoso Legal is based in Leeds, but we also have a base in London, and we work nationally and internationally. The firm was founded in 2007, and we are a world-class IP firm providing business specialist advice, and we've been doing that for actually it's nearly 11 years now. So I'm the head of IP Create and IP Grow. And the majority of my work is based around commercialization of intellectual property and protecting and managing that intellectual property. So this talk today is very much focused on how Brexit and GDPR will be affected or how intellectual property could be affected by that. So next slide, please. Okay, so we're going to go through various different slides. We're going to look at what potential issues we could have on the horizon in light of Brexit, and just look and focus on protecting your IP internationally, what GDPR is and what problems it will cause for exporters, and just businesses generally. We'll also look at avoiding Brexit breakdown, focus a little bit on international contracts and terms, and see if we can predict what's going to go ahead in the future and if there's any real issues. And then we'll do a Q&A session at the end. Okay, next slide, please. So every business has its own individual requirements and issues as far as exporting goes. So this talk is not specifically legal advice for anyone. It's really to highlight and give you a generalized view areas of areas of interest, specifically relating to intellectual property. And so it is not specific advice, but we're more than happy to obviously provide any specific advice outside this webinar. Exporting, as always, is as difficult as it is rewarding. You have to establish supply chains, you have to expand brands, and of course you're developing business relationships internationally. We are aware that it's very hard to stay on top of being an exporter and the competition that's out there. And intellectual property, as hopefully everybody is aware, plays a big, an important role in exporting, and particularly with brands and brand awareness. And new challenges test exporters even more. And today we're going to look at those challenges that you are going to come across. So what are the new issues that you're going to be dealing with? There's two main issues. GDPR is one that's very prevalent at the moment, and myself and Martin have been doing a lot of work with a lot of businesses, small and large, on general data protection rules. These rules come in on the 25th of May, and every single business, small or large, has to be aware of them and at least considered what these regulations say. And it's not that they just affect a business within the UK and how they conduct their business in the UK, it's how they conduct their business internationally, and the effects of processing or sending data, personal sensitive data, outside the EU, outside the UK, and you know, the penalties for not making sure that that is protected properly in accordance with GDPR. So the first thing that we would obviously say is it's a very good time to review your critical business arrangements and look at what should be in place, what isn't in place, and what you need to put in place going forward. Next slide, please. So we'll start with protecting your intellectual property internationally. My colleague Liz and Brian Dixon from Sport Direct did a previous presentation, and I believe that Martin will discuss this at the end of the talk, so you can go and have a look at that if that's something that is of interest. So just as the basics for intellectual property, there are a number of key intellectual property rights that we need to focus on, and then there are critical arrangements that as exporters you'll make contractually with your partners and clients. So let's have a quick tour through those rights. First of all, next slide, please. Trademarks. Trademarks, that is your branding. A trademark can be a word mark, it can be a logo or a device, it can even be a smell or a music or tune. So a trademark covers a wide range of signs. What's important is for any small business is to look at their brand and see if they have it protected. There is a certain level of protection in the UK if you don't register your brands, and you can sue someone on that basis for passing off. But to ensure that you have a strong brand and protect it properly, we would recommend registering your trademark, your brand, registering your brand as a trademark. So some of you may well have those already registered in the UK. If you don't, you need to think about that. It's a very key asset in anyone's business to have a registered trademark. If you're also then going to export, you need to have a look at protecting your key brands protecting your brand in key jurisdictions. It's extremely costly to try and register your brand throughout the world. So the best thing to do is to have some proper strategy advice and consideration about what are your key jurisdictions that you're exporting to, perhaps that you're manufacturing in, and then consider where you would like to register your brand. Obviously, there's always a cost to this, and depending on where you're looking at, so UAE and Middle Eastern countries can be exceedingly expensive to register a trademark over there. You can have, in the UK, you can have a UK trademark, but you can also apply for an EU trademark. And we'll come on to that a little bit later as to what will happen to that EU trademark as a result of Brexit. So if you're a UK exporter, you certainly want to be thinking about registering your brand in the UK. If you export out to within the EU, it might be better to go for an EU trademark. An EU trademark covers, I think it's about 28 countries, including the UK currently. Then there is another system that you can look at to consider whether you want to Madrid Protocol filing, which is an international filing, and that means that you can then look at filing your trademark centrally, but will designate which countries throughout the world, providing they've joined the Madrid Protocol, are covered. So you can apply to make one application which will cover the US, Australia, South Africa, China. There's all sorts of countries that are party to the Madrid Protocol. So you can get, it's a cheaper way of applying for a wider coverage of your brand without going and making national trademark applications in each jurisdiction. So that's the most important thing. Consider your key jurisdictions, look to register in those jurisdictions. Another thing to consider about trademarks is, say, for instance, if you're in China and trading in China, or exporting to China, is perhaps getting a Mandarin translation of your brand. It's not as expensive as you'd think, somewhere like China, and often many of our clients will go for a registration of their brand and also a Mandarin translation. And also make sure you get a proper clearance search before you do any registrations of your brands anywhere, to ensure that there isn't something already on the register that would prevent you from registering your brand. So if you're a startup company and you're creating a new brand, always get a clearance search done before you jump in to use that brand. And ultimately it turns out that you're either infringing somebody else's brand or you can't get it registered. So take proper legal advice on your branding. Copyright, important things with copyright. A lot of people's business assets will be covered by copyright. So software is covered by copyright, website content, technical information. The key thing here is when you're exporting, you might be sending this data out, you might be licensing software. The key thing here is to make sure that you retain ownership of that copyright material. So things like putting copyright notices on there, any agreements where you're licensing materials to people, make sure that it's clear that you retain copyright in those materials. If you're licensing use of your materials to someone else who's going to translate those materials, again, make sure that you own the copyright in those translations. And the way to deal with these sorts of things, particularly with copyright, is to put it in your commercial agreements with your partners. Copyright doesn't actually need to be registered. It's an automatic right, and it is covered. I think I'll go on to a little bit more detail about copyright, but it is covered and enforceable under the Berne Treaty. So providing you've created your copyright work in the UK, it's enforceable in other countries under the Berne Convention. Designs cover things like shape and appearance, you know, so the design of maybe some furniture or the design of a specific material. It can be surface decoration. I'll explain a little bit more detail about designs in a minute, but you have unregistered and unregistered designs. You have UK and EU designs. Obviously, again, same as trademarks, registering those brands, designs is the best protection. It just makes it far easier to enforce your designs if you have a registration. My experience of designs, had quite a few issues in China, and the Chinese, as a minimum, you need to at least show, if you don't have it registered in China, at least show that you have a registered right in the UK or Europe. Then they will take it seriously. And the final intellectual property right that we need to consider is patents. So we have UK patents, you have national patents in any of the any jurisdiction, and you also have a European patent, which is a European, it covers EU-wide, and you apply through the European Patent Office for that one. We're not patent agents, so we don't register patents, but if you are going to get some technology and invention patented, we would recommend that you speak to a patent attorney who would to advise you on the particular jurisdiction that you're looking at. So always consider local representation, and I'll speak a little bit more about how you can actually protect the different types of patents that are out there. With patents, confidentiality is always key. If you have something that you think is an invention that you may want to export, keeping it confidential till you've got the requisite patent protection, or at least filed a patent application, is absolutely vital. Therefore, as IP lawyers, we're forever telling our clients to enter into confidentiality agreements or NDAs to ensure that they give the right protection. Filing patents is also very expensive, so strategic patent advice is vital when you're considering exporting your products. Another thing I would say about just IP generally is making sure that you police your IP, and if you are exporting, make sure you have a keen eye on what is going on in the jurisdictions where you're exporting to, looking to see if anyone else is out there copying your products, making sure no one else is using your brand. And there are certain ways of doing that. Certainly as far as trademarks go, you can put a watching service on that can check you know, all sorts of trademark offices in different jurisdictions to check whether anyone else has actually registered your trademark. Again, that happens quite a lot in China, that if you haven't protected your brand, someone else will register it, and then you have its first right to first person to register, and therefore you lose your brand in that country. Okay, so apart from looking at your intellectual property, next slide please, you also need to think about your commercial contracts which are in place. So just a quick thing about contracts. Whoever you enter or going to do business with abroad, you need to do due diligence on those partners and clients and customers, and make sure that you put some proper agreements, commercial agreements in place. We would always recommend, as a UK exporter, making sure that you draft your contracts under UK law, and with the jurisdiction being UK. It's not always possible, depending on the type of contract. Where possible, go for the UK. It's your business. You don't want to be litigating in Australia. You know, you'd rather be litigating in the UK and be in control of that, and it be under UK law. So always recommend that. Make sure that you have the proper protection, IP protection within those contracts. So secure your IP assets in the contracts, and where possible, limit access and usage of the intellectual property. So make sure that if someone is actually, you're giving someone the right or license to use your trademarks, your branding, make sure you've got the proper branding manuals in place, the proper restrictions, the proper territories in place. Distribution and agency agreements, again, very, very important documents. Very, very easy to make mistakes on these sorts of agreements, particularly with agencies. They can have large ramifications for agencies where there is a termination, there are an indemnity and compensation clause, terms under the EU agency regulations. So you need to think very carefully before you put an agency contract in place. Make sure it doesn't fall foul of the agency regulations. Some people don't think they're actually hiring an agent, and in fact, under the definition of the agency regulations, they are. And as a result, they fall within those regulations, and upon termination of the agreement, they have to pay the agent compensation. Licensing and franchising, again, use the prescribed branding material. Always make sure that you cover your brands off, protect them, have them registered in the local jurisdiction where you are licensing your goods and franchising. And the other thing to make sure is that if you enter into an agreement with someone, perhaps to license, if you're distributing or licensing your products, make sure that you get that protection in place first, because often that occurs where a distributor will register your brand and continue to, and everything is fine until there is a fallout, and then they have your brand and you've lost that brand within that country. Other sort of international commercial agreements, things like your website terms and conditions, seller agreements, consult with regional experts, ensure you focus on your product liability insurance and checks. Do make sure you're with international selling agreements, check your data protection, check all your key clauses. So it's really important to make sure you've got the right commercial contracts in place. Okay, next page. One issue that you could think about when you're going to be trading internationally is it may be more beneficial to have your place of business within the UK, or it might be that you think it's more advisable to set up an international entity and operate under a different jurisdiction's law. So it might be it's better to have an office there or a manufacturing in a different country. It depends on your business. There's many things to think about. There will be tax considerations. In certain jurisdictions, you might not be able to own your own business entity, and you would need a third party to do that, to own it for you. So there's so many different variations there, but it's just something to consider when you are thinking about exporting. Is to take proper advice on the right business structure for you. Okay, so next slide, please. GDPR, General Data Protection Regulation. I'm assuming that most businesses now have at least heard of this and are now hopefully taking steps to do something to be aware of what this regulation states. So there has been quite a lot of panic in the media from various people. There's stories of businesses deleting databases, complete databases, because they can't see any reason how they can actually comply with the GDPR. So the first point with all of this is don't panic. As long as you're thinking about it and know something about it, that's step one. We've been doing a lot of advice here for our clients, and the point with GDPR is it is very vital that you consider how you use personal data, personal and sensitive data within your business, and make sure you have the right consents in place and the right security measures in place.
Yeah, so I'll just jump in here as well. My name is Dr. Martin Douglas Hendry. I'm the Digital Marketing Manager at Virtuoso Legal. So this is something which obviously I work with in terms of our own compliance. So I'm happy to kind of talk about this here. But yes, as Kirsten was saying, in theory, there's some pretty scary fines that are being proposed for GDPR. It's either 2% or 4% of your yearly income, or indeed a large fine of millions of euros, in the tens of millions, I believe, or 20 million, whichever is largest. But ultimately, we believe that the last point on this slide, that much of the immediate impact will be about a loss of business from others who want kind of assurances on data movement. So in terms of how people are working with their partners, we will go to our suppliers, and people who we supply will come to us and ask, are you compliant? And this has a particular relevance to exporters, as we'll find out. So if we just jump onto the next slide, please. So we're not going to run through the whole of GDPR for you. I'm sure you'll be glad to hear that, because I'm sure that you've already been through it a few times. But there are two fundamental points within GDPR that will be of interest to exporters. So the first big point is that a business now, as a data controller, is now responsible for what happens to data after it's shared with others, who are known as data processors. Now, this was always the case under the DPA anyway, but it becomes a lot more specific and onerous upon businesses to understand who they are sending data to, and ensuring that those people that receive that data are using that data in a specified and contractually agreed manner. Now, this comes into play when we think about the second point, which is to say that GDPR protects EU and UK citizens' data worldwide. So any country in the world, when it comes to EU citizens and UK persons' data, has to comply. Within the EU and the UK, obviously this is within the laws of the land, but within other countries, this will have to be within the law of your contractual agreements. So in combination, you're actually responsible for data when it's sent to international partners. This is something that has to be fundamentally written into these contractual agreements. And it's also within the GDPR, you have to be in the position to freely audit your partners to make sure that they are actually complying, and they've not simply just agreed, but then have given that agreement short shrift. And there will have to be policies of renewing that kind of audit to ensure that that is indeed the case. Yeah. So yes, as we're saying, relationships with international partners, strongly secured, and of particular interest are countries with bad reputations in data protection, or comparatively bad as GDPR comes into force. This will require particular attention in terms of making sure that those contracts are firmly in place. So in terms of, we're just having some issues again with the sound there. Yes, so the main point being that all of this was the case under data protection law previously, and it was just best practices, but now it's something that has to be the norm. And we will find that the general data protection environment will improve as companies will want to continue to work with other companies, and we'll just have to kind of reach that standard. So that's your main part as far as GDPR goes. So I'll just pass back to Kirsten as far as Brexit goes. And again, apologies for our issues with the sound. We're going to see if we can remedy this as best as possible.
Okay, next slide, thank you. Avoiding Brexit breakdown. Currently, UK businesses adhere to UK and EU law, and EU law can supersede domestic law. Well, this is not for long. When Brexit comes in, there are many changes to intellectual property, such as trademarks, patents, copyright, and design rights. However, as you will see from when we go further on, that actually the changes that, and there's been a lot of sort of scaremongering here, I don't think the changes are going to affect us that badly. What you will need to do is check that you have the right protection for your intellectual property, and that you will need to check all your contracts for IP and for data protection. There is no doubt, as far as data protection goes, that you will need to have GDPR compliant clauses within your business supply arrangements, with your supplier agreements. If you have terms of business, many people, rather than updating their agreements, are sending out addendums and asking suppliers to accept those addendums as variations to your current terms of business or contract seller arrangements, licenses, anything of those sorts of agreements. So some steps do need to be taken as far as that's concerned. Next slide. The first area of intellectual property that I'm going to focus on is trademarks. I've already talked a little bit about what a trademark is. Trademarks are territorial rights. So how do you protect your trademarks? Currently, you can either register a trademark as a UK trademark, or you can apply for a community registered trademark. A community registered trademark covers 28 of the European Union countries, and that includes the UK. So this will stop once with Brexit. I think it has now been agreed that all existing European, a lot of people would choose to have a European trademark as opposed to a UK trademark, because obviously it covers UK and many more countries. So the real issue is how will this be dealt with Brexit? And it has been decided that existing and pending EU marks will be effectively duplicated and carried over in the UK. So cover the UK, you will have an EU mark and a UK mark covering the same classes of goods and specification and the same brand. So one of the things you need to think about is if you are registering a new brand, you need to think of filing separately UK marks and EU marks rather than the normal just going for an EU mark. Next slide, please. Okay, so one of the key issues for trademarks is that a trademark can be revoked for non-use if a third party so wishes to apply for revocation of a trademark if the trademark has not been used within the last 5 years. And this is an important issue when we have the split and the division between an EU mark and you have the duplicate UK mark, that if you have only been using your brand in the UK and not really in the rest of the EU, that your EU mark would be open to being revoked for non-use. So it's a real issue. Is in reality going to happen? I think it's unlikely that there's going to be loads of instances of loads of people applying to revoke other people's trademarks for non-use, but it certainly is a potential problem as a result of Brexit and an implication for trademarks. So if you have an EU trademark and it is going to be duplicated in the UK, do consider very carefully a strategy to make sure and to prevent your EU element of your brand registration being revoked for non-use. At the moment, we're not sure of the actual mechanism of how an EU mark will be duplicated within the UK, but we also so we need to sort of wait to hear how the actual mechanism is going to work. We're not sure whether any costs are going to apply at that stage, or whether there's just going to be an opt-in process. So we will have to wait and see, but at least we know that there is protection there for an EU mark and a UK mark now, and that will occur. The next intellectual property type of intellectual property to look at is designs. There's two types of design rights. There is registered designs and there are unregistered designs. And in the UK, you would have protection from UK designs, and you would also have EU design right laws as well. And when Brexit happens, the UK will no longer be covered by the EU registered and unregistered design rights. So in the UK, you have a registered design right which lasts for 25 years, and you have an unregistered right which lasts for 10 to 15 years. In the EU, there is a registered right which lasts for 25 years and an unregistered right that lasts for 3 years. Do you want next slide? Thank you. So what is the problem with us losing the EU design rights, registered design right and unregistered design right? Arguably, UK, there's no difference for the UK registered rights the EU registered rights. They both last for 25 years. They both cover the appearance of whole or part of a product resulting from the lines, contours, shape and colours, textures, etc. Copying is not required for EU or UK registered designs. What is required is that the actual design is novel and possesses individual character. So far as UK registered designs and EU registered designs, there's not much difference, but there is a difference in relation to the unregistered design rights. As I said before, EU registered design unregistered design is only for 3 years. However, it covers far more design features, and it is the same as a registered design in the fact that it will cover the appearance of a whole or part of a product resulting from line, contour, shapes, colours, texture, surface decoration. So an EU unregistered design right has a much wider scope than a UK one, and whilst an EU unregistered design right is only for 3 years, the UK one is for 15 years, but it only covers the shape and configuration. It's much more of a commercial design than surface decoration. For unregistered UK and EU design rights, copying is required, and although the rights are automatically protected with no registration, the designs only will survive, be in existence if they're not commonplace, i.e. if there's an element of novelty as far as the UK unregistered design rights. So the point on all of this is that arguably an EU unregistered design right gives far wider protection than a UK one, and on that basis there is a strong suggestion that the UK will now have to look, once we lose the EU unregistered design right, and change our law on that respect. Okay, copyrights. The UK and other countries operate on a domestic law which is enforceable internationally by the Berne Treaty. So in the UK, everything that is protected for copyright is copyrighted under the Copyright Designs and Patent Act. It's automatic, there's no registration required, and it can be enforced by all in any countries which are signatory to the Berne Convention. Copyright protects original literary, dramatic, musical or artistic works, sound recordings, films, broadcasts, etc., etc. And it protects the expression of those ideas, not the ideas themselves. So for something to be protected by copyright, you actually need to have it recorded in some shape or form. If it is a song or music, you need to have that recorded. If it is a poem, it needs to be written down before it is protected. So that's what copyright covers, and it covers up to different copyright has different lengths of protection. Literary copyright, you're looking at 70 years from the date of death of the author. So it lasts for a very long time. You don't need to register it. It's enforceable in other countries. And the EU is keen to establish a union-wide right. However, this has been considered to be quite ambitious, and we'll have to wait and see. But ultimately, Brexit won't have an impact as far as copyright goes. There'll be no changes there. Interestingly, in the US, you can actually register your copyright, and in order to enforce it, you need to have it registered in order to do that. So, right, okay, the final intellectual property right to really consider is patents. Patents is a legal right for a new invention, and it lasts for a maximum life of 20 years from the deadline for your patent. You can apply for a patent in the UK. You can also currently apply for a European patent, which effectively you make one application. You have the option of 38 countries to choose which countries within the EU you want to be covered, and it is examined centrally, and then you have a group of national patents at the end of it. You can also have what is the closest to a worldwide patent, but what it is effectively patent cooperation treaty. It's an international patent system where you file a single application. It is then split up into the separate national countries, and it is examined by each individual country, and you end up with a national patent within each country. So there is no effectively worldwide patent, but there is a system of filing under the PCT to make filing less expensive. There is and has been for a long time discussion, and is now proceeding, is the creation of a unitary patent, which would result in the creation of the Unified Patent Court. It's taken a very long time for all the parties to agree on creating this unified unitary patent. Massive arguments about translation and whose language it should be in, and all those sorts of things. When this comes into effect, it will alleviate the slow process that has been occurring before when you want a European patent by applying through the EPO and then having a group of national patents. This will be one single patent covering the countries who have all joined in this agreement. The good news here is that it has nothing to do with the European Union, so therefore this will continue, and the UK will be part of that system and be able to have a unitary patent. So that's all very positive, and you know, Brexit has no effect on that. One of the things with patents that is key is, and I've said it before earlier on, is that you must make sure that you keep your invention confidential. If you're going to disclose it to anyone for any particular reason, a manufacturer maybe, it is vital that you do it under the terms of a confidentiality agreement, and that is not made available to the public in any way, shape or form, as it will invalidate any patent application that you make.
I suppose that's quite interesting as well, internationally speaking, because if you've revealed it in one country and you're looking for then patents further afield, that may still constitute, presumably, exposure of the inventions.
Absolutely. I mean, when you apply for a patent, you secure your filing date before it is published. You can make further applications to look at maybe internationally to secure your patent protection, and there's different timelines upon when you have to do certain things to ensure that you can still do that and have protection there. But when they're looking at whether your patent, one of the things for patents is that it has to be an invention, it has to be novel, and it has to have an inventive step. An inventive step is something beyond what is just a variation on what is already out there. Novelty, they look at prior art, and the prior art, that's worldwide. So if someone has seen it in a different country, but in Australia or something very similar in Australia, or written about something similar in Australia, we're trying to apply for a UK patent for any sort of disclosure anywhere in the world. So that's key. Just quick, as time's moving on, quickly onto international contracts and terms. Next, thank you. Next one. Many concerns for exporters in the light changes to intellectual property and data protection. So what we would say is important to assertively deal with these priorities first. Some of these changes affect everyone, others just affect some businesses. So take the stand to review all your agreements where they refer to IP assets and personal data, and make sure you get the relevant amendments included. So a sort of internal audit of your documentation, get them up to date with new GDPR compliant clauses, check your supply contracts, check your data protection policies, and internally deal with your data and security measures to ensure that you don't fall foul of GDPR. Next clause, next one. So data protection, safeguarding of personal data in supplier agreements, auditing of ability to comply, watertight GDPR compliant agreements with companies outside the UK and EU, all by the 25th of May. I have to say that I don't think that's going to happen, and many companies will not be GDPR compliant. But one of the things we've been advising our clients is take those initial steps, speak to someone about GDPR, do an internal audit to look at your use of data, where it's stored, and just start to make those steps. Contact suppliers that you may send out personal data to make sure that they're aware of GDPR, and get their comfort from them that they're going to be GDPR compliant in the handling of any data that you send out. And obviously this is crucial when you're dealing with companies and businesses outside the EU. Registered intellectual property, review the registration status of all your registered intellectual property rights, and ensure that that status remains after Brexit. Ensure that your agreements with partners in relation to this are up to date to reflect the changes. So ensure that your UK mark, when you get your new UK mark, that's covered in the agreement. And that's just a reiteration of what I've already said. Agreements with others must be agreed on the basis of laws of England and Wales to be enforceable by UK company within the UK. So you want UK law as a preference and UK jurisdiction, if at all possible. And that, I think, oh, what lies past, next one.
Yeah, so finally, just to kind of conclude a very long-winded and perhaps, well, say stormy journey through these changes, the main thing that we're looking to suggest is it's all about being proactive and kind of with these large kind of unilateral changes that are happening in the law, look at these as actually opportunities rather than inconveniences. Really being proactive can create success where other people who are a little bit slower off the mark are not not actually kind of addressing these issues. And again, it's vital not to kind of procrastinate and just to even perhaps go a bit above and beyond. Be sure to send your in-house counsel off on a good holiday this year, simply because it will be a very stressful year for them. But ultimately, keeping abreast of the law will only offer you more and more opportunities to kind of move forward in the best way possible. And I believe that should bring us to the end of the slightly longer end of a presentation than perhaps initially agreed. So hopefully that's not been too much for everybody.